Hello, my name is Mark Belanger. I'm a graduate student at Eastern New Mexico University in the MBA program, and I'm doing a presentation here today for my Law, Ethics, and Social Responsibility class, Business 501. So today I'll be doing a presentation on the Statute of Frauds. First I'll address the origin of those statutes. Then I'll address the definition, and then we'll take a look at some of the what's required of that statute and some examples of what fall under that statute. And then we'll just take a look at, just a brief look at the effects on the current time frame in our current years here where we address technology, electronics, and so forth. So like I say, first of all, the origination of the Statute of Frauds originated back in 1677 in the English Parliament. Now, the Statute of Frauds was enacted to protect innocent parties from fraudulent claims based on perjured testimony. Now, the parties involved in lawsuits back in that era were excluded from testifying in their own behalf. So, with that being said, the statute was primarily concerned with ensuring that where a contract existed, there'd be reliable evidence of it. Hence, there came forth that requirement of writing the Statute of Frauds. So, now with that being said, I'd like to give you the definition of the Statute of Frauds. According to Cornell Law, the definition is a statute requiring certain contract to be in writing and signed by the parties bound by the contract. Now, like I said earlier, the purpose of the statute was to prevent fraud and other injury. Okay. Now, with that being said, there are some different contracts and agreements that I can provide here that will be examples that fall under that statute of fraud. First of all, one is a contract of an executor or administrator to answer for a descendant. Two, a contract to answer for the duty of another. Three, a contract made upon consideration of marriage. Four, a contract for the sale of or an interest in a deed of property or in land. Five, a contract that will not be performed within 1 year. And also the last one would be a contract for the sale of goods or services in excess of $500. So those are just, a handful of the types of contracts and agreements that would fall under that, be susceptible to that Statute of Frauds. Now, with that being said, next of all, I'd like to address, as we said in the Statute of Frauds, it hints the biggest thing with it is in writing. So now when they say in writing for the contract, I'll address a few things that they look at with this. Now, first of all, there's no specific guideline that the written contract must follow in order to satisfy those Statute of Frauds. But there are a few things that you can ensure that the contract addresses that will help you in these situations. First of all, identify the parties. Make it clear who the parties are to the contract agreement. Secondly, set forth the terms. What is being provided, what goods or services are being exchanged between the two parties, or so forth. And third of all, indicate the party's intent to be bound. What I mean by that is, take a look, make sure there's signatures, make sure there's acknowledgments on that contract. Now, with those three things being said and addressing those three areas in that contract, written contract, let me remind you, however, as long as a court can comprehend the essential terms of that deal or contract, the writing will meet that test. So those are just a few basic guidelines to follow with that, the agreement to make sure they were in writing. Okay. Now, with that being said, next I just want to take just a brief minute to take a look at how the Statute of Frauds affects us here today in 2015. Like I say, with the advent of technology and computers and electronic emails and so forth, it's really changed the face of the statutes a little bit. For example, now the requirements where they say in writing and a signature required, now, with the advent of email, a lot of times agreements are done back and forth through an email with, automatic signatures done through email. So now when we look at writing, we can go back now and say, you know what, those emails are hard copied, stored in the hard drive of those computers. So if we can pull those out and print them later, that meets the test of saying it has to be in writing according to that statute of frauds. So there are some differences there now that we have to address. Now, one of the things, like I say, with the electronic messages, there's several methods available out there. You know, we've got exchange of emails, electronic data interchange, direct electronic links between vendors and purchasers, website forms. You know, there's the opportunity when you go into download or songs or contracts or services, you're accepting agreements, and there's boxes there where you accept, even though you're not physically signing, you've clicked on the box and accepted it. So there's different ways of acknowledging and showing your intent to be bound by different agreements for services and goods. So now, once again, with that being said, there has been some legislation that came forward which addressed electronic contracting. One of those is the Federal Electronic Signatures in Global and National Commerce Act. And basically what that said in Section 101A of that section, it said a signature, contract, or other record relating to such transaction may not be denied legal effect, validity, or enforcement solely because it is in electronic form. And two, a contract relating to such transaction may not be denied legal effect, validity, or enforceability solely because an electronic signature, electronic record was used in the formation. So that just gives you a little bit of how legislation nowadays in 2015 and going forward has to address some of the different advances in technology on how we do that. So hopefully that just gives you just kind of a brief synopsis, a little overview on the statute of frauds and how that works a little bit, and you know, how it's come forward and moved into technology. So with that, I'd just like to say thank you, and I hope you enjoyed the presentation.